Chapter 20, Agency and Liability to Third Parties, presented by Kelly Herzig. You may be wondering why we skipped from Chapter 7, Torts, all the way to Chapter 20, Agency. And that is because agency law spans both tort law and contract law. We just finished up tort law in Chapter 7, and agency law rounds that out nicely. And it's a preview to what we're going to be doing next week, which is an introduction to contracts. In this lesson, we will discuss agency law, creation of the agency relationship, the agency relationships themselves, duties of the agent and the principal, rights and remedies, authority of the agent and the principal's liability, contractual liability of the principal and agent, and termination of the agency relationship. Let's begin with the definition of agency law. Agency is defined as a fiduciary relationship between a principal and an agent. A fiduciary relationship is a relationship based on special care and trust. It's higher than a general contractual relationship. An agent is a party who has the authority to act for and bind another party. A principal is the party who appoints an agent to act on their behalf and who is bound by the agent's authority to act. Agency arises from the fiduciary relationship created when one party, the principal, consents to have another party, the agent, act on their behalf, and the agent is subject to their control. That's an important key point, is that the principal controls the agent's work. An agent must consent to being appointed as an agent. You can't unknowingly make someone your agent. Agents are generally considered fiduciaries, meaning they act primarily for another party's benefit. Agency law is based primarily in state law, and that can differ from state to state. So when we talk about agency relationships in this chapter, you bear in mind that if you're in a different state than Kansas or in a minority state, you will have to check the rules on agency in that state if you're going to be doing business there. American companies often hire foreign agents to help navigate foreign markets, foreign laws, and customs. If you're overseas, many times you don't know the customs, you don't have the contacts, and so you hire an agent to represent you in a foreign country. How is an agency relationship created? Agency relationships are primarily contractual, meaning they are based in contract law. Agency relationships can be established by a written contract or even an oral contract. They do not have to be in writing. However, an agency relationship is only created when the principal asks another party to act on behalf of the principal. You cannot have an unknowing agent. An agency relationship can only be created for a lawful purpose, and almost anyone can be an agent. When I say that it has to be created for a lawful purpose, it cannot be a criminal enterprise. That is a RICO violation, a racketeering violation, because you cannot have an agent acting on your behalf to go commit a crime on behalf of the principal. A contract made by an agent is viewed as a contract between the principal and a third party. It is not a contract between the agent and the third party. Therefore, a person can serve as an agent regardless of their age or competency. However, minors and the legally incompetent cannot hire agents as they have no contractual capacity. Minors and those who have been deemed incompetent under the law cannot enter into contracts, and hiring an agent does not cure that deficiency. There are four forms of authority used to create an agency relationship. An agency can be created by express authority, which is also known as agency by agreement, by implied authority, by apparent agency, which is also known as agency by estoppel, and by ratification. Let's begin with express agency, which is also agency by agreement. This is the most straightforward type of agency. It's when the principal and the agent enter into a contract, oral or written, to form the agency relationship. The agreement will specify the scope of the agency, what the agent is allowed to do on behalf of the principal, and the contract authority of the agent. The agent's authority can be broad or narrow in scope, and either can be an exclusive or non-exclusive type of agency. Real estate contracts are usually exclusive types of agency. For example, if you hire a real estate agent to list your house, on average, those are 6-month contracts and they are exclusive with that agent, meaning you cannot hire another agent to compete with the first agent to sell your house. If the agency agreement is in writing, the agency contract must meet all the general requirements for a contract, and we'll talk about what those are in later chapters. Powers of attorney are one way express agency can be created. A power of attorney gives the agent authority to sign legal documents on behalf of the principal. It can be a general power of attorney, which is broad, meaning the agent can sign virtually any kind of contract on behalf of the principal and bind the principal to that contract, or a specific power of attorney with limited enumerated rights granted to the agent. I never recommend my clients sign a general power of attorney, particularly if the agent is going to be a family member. I think that it leads to problems within a family. It's much better to have a specific power of attorney which lists out the rights of the agent and what authority they have so that there are no problems down the road. A durable power of attorney is a special form of power of attorney which lasts even after the principal becomes incapacitated. These are often used for healthcare purposes and must be entered into before the principal becomes incapacitated. Suppose you have a parent who is diagnosed with early onset of Alzheimer's. That parent will probably want to execute a durable power of attorney for health care before the Alzheimer's progresses to the point when they are no longer able to make decisions on their behalf. They will want to have someone holding a durable power of attorney for health care who can make those decisions for them when they can't. While agency agreements do not need to be in writing, there are exceptions. For example, if the goal of the agency falls within the statute of frauds. This is a contract concept, and it concerns the sale of land, the sale of goods over $500, or contracts needing performance for a year or more. Then, if it falls within that statute of frauds, the agency agreement has to be in writing. An agent can act without pay. They are considered gratuitous agents. Attorneys sometimes are gratuitous agents when they act pro bono, meaning they don't accept pay and represent a client for free. It doesn't make them any less an agent, they're just not being compensated. The next type of agency is implied agency. Agency relationships can be created impliedly by the conduct of the parties being the principal and the agent. Circumstances of the relationship determine the extent of the agent's authority to act on behalf of the principal. Implied authority cannot conflict with any express authority given by the principal to the agent. An example is if Betty wants to go and buy a car, she goes to the dealership. The salesperson, acting on behalf of the dealership generally, offers to give Betty some additional options on the car for free. The implication is that the salesperson has the authority to offer the incentives on behalf of the principal, since it would be implied from his employment and circumstances that a salesperson can negotiate the sale of the car. The next type of agency is apparent agency. Apparent agency, also known as agency by estoppel in some states, is not created either expressly or impliedly by the principal and agent, but by operation of law. It occurs when one party, by his actions, makes another party, a third party, believe that another party is his or her agent, when that person actually has no authority. Then the law will create an agency by estoppel relationship to protect the innocent third party. When the innocent third party makes a deal with the apparent agent, the principal must uphold the deal made by that apparent agent. However, and this is a key point, the third party must demonstrate that he or she reasonably believed, on the basis of the principal's conduct, that an agency relationship existed. You cannot rely on what the agent tells you. It has to be something that the principal does to make you believe that someone is acting as an agent on the principal's behalf. It is the principal's conduct that controls. For example, a plaintiff is represented by an attorney. The attorney makes an appearance in the case and acts on behalf of the plaintiff throughout the case. The parties ultimately negotiate a settlement through their attorneys and the case is dismissed. Plaintiff will have a hard time setting aside the agreement for lack of express authority by the attorney, because his actions in letting the attorney represent him and negotiate a settlement, he leads the defendant to believe that the attorney could settle the case. This is the fact pattern in the case nugget on page 426, and you will see this again. The last type of agency is agency by ratification. Agency by ratification is an after-the-fact type of agency. It's created at the end of a deal rather than at the beginning. The agent makes a deal on behalf of the principal, misrepresenting his authority to make the deal. But at the end of the deal, the principal honors the unauthorized act and accepts the deal. The principal in that instance has ratified the agent's authority if 1, he has complete knowledge of all the material facts regarding the contract, and 2, he ratifies the entire contract, not just parts of the deal. You can't pick and choose. You have to decide that the deal negotiated by the agent is one that you're willing to accept, and that means you are ratifying the contract. For example, at the car dealership, the salesperson offers Betty a lower price on the car she wants along with the free options. While the salesperson had the authority to offer the free options, he misrepresented his authority to Betty because he had no authority to offer a discount on the car price. If the dealership nonetheless reviews the deal offered to Betty and decides to honor it, the dealership as principal has ratified the salesperson's unauthorized authority to offer the discount. Would apparent authority also protect Betty? The answer to that is maybe. Remember, it would depend on something that the dealership did to make Betty think that the salesperson would have the authority to give her a discounted price. Types of agency relationships. In business, there are 3 relevant types of agency relationships: principal-agent, employer-employee, and employer-independent contractor. Principal agent. This occurs when an employer hires an employee to enter into contracts on behalf of the employer. For example, a sports star hires an agent to represent him in negotiating endorsement contracts. Or a corporation expressly delegates contract negotiations for buying a building to a vice president of acquisitions. Employer-employee. This occurs when an employer hires an employee to perform a physical type service. For example, a clothing store hires a sales clerk to sell clothes in the store. Employees are under the control of the employer and are generally considered agents of the employer. Even those without authority to enter into contracts or interact with third parties are considered agents. Under the law, a corporation can only act through its officers and employees, and any act or omission of an officer or employee is the act or omission of the employer. Not all agents are considered employees. In the employer-independent contractor relationship, an employer may hire a party to act on his or her behalf that is not an employee, but is rather an independent contractor. That's an important distinction in both contract and law. An independent contractor is a person who contracts with another to do something, but is not under the employer's direct control. The employer does not control either the independent contractor's work conditions or methods, meaning that the employer does not direct the independent contractor in the day-to-day performance of his or her duties. The employer may provide direction and goals, but does not direct the details. The details of the performance of the action are left to the discretion of the independent contractor. For example, the employer may give an ultimate goal and some overarching direction to an independent contractor that deals with buying a building. But how to get there and the details of locating the building are left to the independent contractor. Examples of independent contractors are doctors, lawyers, stockbrokers, and building contractors. Many times these are professionals with specific expertise that the employer does not have. An employer may hire a lawyer, for example, to act on behalf of the company in a lawsuit. But the company does not tell the lawyer how to practice law. The company may have a goal in how to resolve or deal with the lawsuit, but they're relying on the lawyer's expertise in the day-to-day representation in the action. While independent contractors are not employees, they're also not always agents. They must have actual authority or apparent authority from the employer to enter into contracts. I don't automatically have authority from my client to settle a case on their behalf. They have to give me authority, or there has to be circumstances that create apparent authority for me to settle a client's case. How do you tell when a person is an employee or an independent contractor? Whether a person is an employee versus being an independent contractor can have major implications as to the person's compensation, workplace safety rights, and unemployment rights. If a person is an employee, they're protected by and have rights under such things as wage and hour laws, workplace safety standards, family leave protections, employment discrimination laws, and unemployment statutes. Independent contractors do not generally have these protections. For example, if you're an employee, you get payroll deductions. You may make $1,000 a week, but your employer will take out all of your contributions for income tax, Social Security, and Medicare. If you are an independent contractor, you will get the gross $1,000, but then you will have to pay your own payroll taxes directly for income taxes, Social Security, and Medicare contributions. You don't get it done for you, you have to do it yourself. Further, employers are generally liable for the acts of their employees in tort, while they are generally not liable for the acts of independent contractors who they do not control. Control is the key in determining whether a worker is an employee or an independent contractor, but there are other factors, and they're in Exhibit 20-3 on page 430, and that lists all the factors that are considered when the employee independent contractor relationship is determined. But I think for testing purposes, if you remember that employers don't generally control independent contractors like they do employees, you'll do okay. Next, we'll discuss the duties of the principal to the agent. Because the agency relationship is a fiduciary relationship, certain duties arise between the principal and the agent under both the agency contract and the law. The principal's duties to the agent are the duty of compensation. It's basically the duty to pay the agent for his or her work. Usually that's laid out expressly in the contract, exactly how and in what circumstances the agent is going to be paid. Occasionally it has to be applied from the circumstances, but that doesn't happen very often because most people, if they're going to do work for someone, want to know how they're going to get paid. The exception for that, of course, is gratuitous agents who are working for free. Then there is the duty of reimbursement and the duty of indemnification. The duty of reimbursement is simple. If the agent in the course of the work for the principal incurs expenses like meals, hotels, mileage, gas, then the principal has the duty to reimburse the agent for those expenses. In addition, the principal has the duty to indemnify the agent for any losses the agent incurs. For example, if I as an attorney settle a case with the client's authority, then the client refuses to pay the settlement, I could get sued by the other party for the damages for the failed settlement. The client, as the principal, will have the duty to indemnify me as the agent and attorney for any losses I have and that are recovered by the third party. Then there is the duty of cooperation. The principal must cooperate with and assist the agent as needed and must not impede the agent's work. What's the point of hiring an agent if you're just going to put roadblocks in their way? Then there is the duty to provide safe working conditions. If the independent contractor is going to be on your premises, then the principal must provide a safe premises, equipment, and other safe working equipment, and has a duty to warn the agent of any unsafe working conditions. The principal also has the general duty to remediate unsafe areas. It's basically that the independent contractor, even though they may be an independent contractor not under your control in the day-to-day performance of their duties, if they're going to be physically located on your premises, you need to treat them with the same care in terms of workplace safety that the employees have. Agents also have duties to their principal. Agents' duties to the principal are the duty of loyalty. An agent has the obligation to act in the best interest of his principal, avoid conflicts of interest, and protect the principal's privacy and confidentiality. In addition, the agent must keep information about the principal learned through the course of the agency confidential, even after the relationship is terminated. An example of this is the attorney-client relationship. If I am hired by a client to negotiate a real estate contract, my job is to negotiate the best possible deal for my client that I can. I cannot make side deals to try to make extra money. That would be a conflict of interest. I have to work for the client's best interest and not my own. And I also have to protect the client's privacy and confidentiality. They may give me information about their business that they don't want generally known and that they don't give me permission to disclose. I have to keep that information confidential throughout the course of the representation and even after the case is over. The contract may be negotiated, I may get my final payment, but the case still has confidential information that I have to keep quiet, and that happens even after the relationship is terminated. Then there's the duty of notification. An agent has the duty to communicate any offers from third parties and has the duty to notify the principal of any pertinent information that is discovered during the course of the agency. This is important because the law presumes that the principal is aware of what the agent knows, regardless of whether the agent actually shares the information. For example, suppose I'm representing a client in a lawsuit and the opposing party makes an offer to settle. Even if I consider it a lowball or ridiculous offer, I still have to tell my client that an offer was made so that they can then review it, and if they want to settle, they can, or if they want to reject and counter, they can. Then there is the duty of performance. An agent must perform the work specified in the agency agreement and must do his or her work with reasonable professionalism, skill, and care. A good example of this is an attorney retainer letter. When I'm hired by a new client, I send them a letter that lays out my understanding of what the scope of the representation is and what I'm expected to do and how I'm going to get paid. I have a duty as an attorney to act with skill and professionalism as the same or similarly situated attorney does. Then there is the duty of obedience. An agent must follow the lawful instructions and directions of the principal. Example, I have to settle cases at the direction of my client. I can't just go off and decide, I think the case is worth $10,000, so that's what I'm going to settle it for. I have to have express authority from my client to settle for that amount. Then there is the duty of accounting. The agent must keep an accurate accounting of transactions made and expenses incurred. An agent must keep his and the principal's accounts and money separate. A good example of that is the attorney's business trust account for client money. I can't commingle money between my office and the client's money. I have a separate account called a trust account where client's money goes in. I have to keep track of every expense that I have that's on the monthly bill in detail, and I have to detail every entry and every time entry that I do for a client. I have to keep an accounting. Next, we're going to discuss the rights and remedies between the agent and the principal. Because the agency relationship is primarily a contractual one, if the agent breaches his fiduciary duties, a principal has remedies available for harm caused by the agent's breach. He can also terminate an agent for breach of contract. The principal's rights and remedies against the agent are many, but the three main ones are constructive trust. Principals are the legal owners of property or personality that an agent may possess as a result of the agency. If an agent, through deceit or breach of his duties, retains profits or goods that should rightfully go to the principal, then the law imposes what is called a constructive trust on the purloined property or goods. This means that the agent will be found to hold title of the property or goods in trust for the principal, who will have legal right to them. It's basically a construct in the law that allows the principal to recover from an agent who has breached their duties or actually committed fraud. Then there is avoidance. When a contractual agent negotiates a contract outside his or her duties, the principal may nullify the agency contract at his or her discretion. Basically, if the agent breaches their duties, you can fire them. The third right and remedy that a principal might have against an agent is indemnification. Agents enter into contracts on behalf of the principal. If a third party enters into a contract with the agent who he believes is acting with actual or apparent authority, then the contract is binding on the principal. However, what if there is a breach? The third party may sue the principal for breach of contract because they are bound on the contract. However, if the breach of contract is ultimately caused by the agent's negligence and the principal is innocent, the principal can seek indemnification from the agent for any losses on the breach of contract. What happens is the third party sues the principal because that's who they were in a contract with, and then the principal will have to pay damages to the third party. Those losses he can turn around and seek indemnification from the agent for, and the agent will ultimately have to pay the principal back for the losses. A principal can also sue an agent in contract and recover for the agent failing to follow the principal's instructions. Going against the principal's general advice is not actionable, but ignoring limiting instructions is actionable. For example, suppose a principal lists a piece of property for sale through an agent, but later on the principal decides that they don't want to sell the property anymore, they just want to lease it. They have to tell the agent that they just want to lease the property and not sell it. That's called a limiting instruction to the agent. Then the agent is bound by the limiting instructions. In other words, they can no longer list the property for sale or sell the property. They can only rent it. And if they sell the property, that is a breach of the agency contract and a breach of the limiting instruction. To avoid lawsuits from third parties, a principal should notify those he knows the agent has dealings with when the agency relationship ends or when a limiting instruction is given to the agent. For example, in the previous example over the real estate, if the principal knows that there are certain parties who've been interested in looking at the property and buying it and have maybe made offers that have been rejected or are being negotiated, they might call those people and tell them that, hey, I'm no longer going to sell this property, I'm only going to rent it. The agent only has the authority to rent the property now, not sell it. The agent also has rights and remedies against the principal. An agent has standard tort and contract remedies. The agent has traditional tort and breach of contract remedies depending on the terms of their written agency contract. Demand for an accounting is a powerful right of an agent. When an agent feels he or she is not being properly paid, especially on a commission basis, the agent can demand an accounting from the principal. While the accounting is pending, an agent may withhold further performance until the principal provides the accounting data showing how the agent is being paid. Basically, the agent doesn't have to work and get further in the hole until they know they're being paid properly. Then there is specific performance. When there is an agency contract and the principal agrees to certain conditions but fails to perform, the agent can seek court assistance in forcing the principal to perform the contract as written. This is called specific performance. Courts don't like specific performance. It's not favored in the law. The court does not like to force someone to perform duties in a contract that they don't want to perform. If there is no written contract, or the contract is for personal services, like for example, a singing contract, you're going to come and sing the national anthem and you decide you're not going to do that, the court is not going to force specific performance and make the singer come sing. The agent cannot sue for specific performance normally under those conditions, but if they do, the court will dismiss the specific performance count and instead force the agent to seek standard remedies, like damages for breach. Next, we're going to discuss the authority of the agent and the principal's liability based on that authority. So let's take a quick review of agent's authority. There's express or actual authority. This occurs when the principal has explicitly given authority to the agent. That there's no question that the principal has hired the agent and the agent has authority to conduct the business at hand for the principal. There's also implied authority. This occurs when the words and actions of the principal create an inference of authority granted to the agent. Implied authority can be found through custom and conduct of the parties. For example, a store manager may not be given a written exhaustive list of his or her authority by the owner of the store. Rather, the manager has implied authority to carry out her duties to achieve the principal's goals. Then there's apparent authority and estoppel. This is when a principal, through his own actions, and that's the key, it has to be the actions of the principal, not the agent, who makes a third party believe someone is an agent of the principal with authority to act. This creates an apparent agency. If the third party reasonably believes the person presumes to be an agent has the authority to represent the principal must honor any contract made. Now, this assumes that the reliance by the third party on the agent's representations is reasonable and that they had a change of position. In other words, they actually did something in reliance on the agent's apparent authority to their detriment, like they sold a piece of property or entered into a contract. There has to be some change in position by that third party to bind the principal. Then, if there is, the principal is legally estopped from denying the agency relationship or the agent's authority. Next, we'll discuss contractual liability of the principal and agent. To determine liability to third parties, courts look to determine the classification of the principal and whether the principal authorized the agent's actions. Let's start with the classification of the principal. Classification of the principal is made from the perspective of the third party, meaning that the extent of the third party's knowledge of the principal determined the principal's classification. The easiest is the disclosed principal. This is when the third party is aware that the agent is an agent, that the agent is acting on behalf of the principal, and the third party knows the identity of the principal. That's a disclosed principal. Sometimes you have what they call a partly disclosed principal. In this instance, the third party knows the agent is acting on behalf of a principal, but doesn't know the identity of the principal. For example, suppose I'm representing a large corporation like Disney that wants to buy land for a new resort. Well, I don't want the public or third parties to know that Disney is interested in buying the land because the price will go way up. I may want to tell them that I'm acting on behalf of a principal, but I'm not going to tell them the name. That's partially disclosed principal. And then, of course, there's undisclosed principal when the third party does not know the agent is acting on the behalf of a principal at all. If I'm working for Disney, I may be acting like it's just me buying the land and not my true principal. I may not even let them know that I am an agent. I may appear to be a principal to a third party. That is undisclosed principal. Who is contractually liable for the authorized acts of the agent, the principal, or both? When an agent acts within the scope of his authority on behalf of a disclosed or even partially disclosed principal, the agent is not liable for the acts of the principal. The principal is generally liable only if the agent has actual or apparent authority to act on the principal's behalf. If the principal is disclosed, the agent is not liable on any resulting contract because the agent is not a party to the contract. Only the principal and the third party are. If the principal is partially disclosed, the agent can be held liable on the resulting contract made with a third party because the courts treat the agent as a party to the contract in most states. It's a risk you take as an agent. It's a trade-off. If you want to keep your client's name private, that the principal remains undisclosed, then you risk being a party to the contract and being liable for breach. If the principal is disclosed or only partially disclosed, they are liable to third parties on any contract made. Basically, as long as a third party knows they are dealing with the principal, whether they know the principal's name or not, the principal will be liable on any resulting contract made by an agent within the scope of their authority. Who is liable when the principal is undisclosed? Usually when an agent acts within her authority for an undisclosed principal, courts will hold the agent liable on the resulting agreement with third parties. And why not? The third party doesn't know that the principal exists. They think they're in a contract with the agent, not the principal. If the principal is undisclosed and the agent is liable to third parties in contract, the principal will also be liable to the agent through indemnification, except under certain circumstances. The first is when the agency contract expressly excludes the principal from the resulting contract. Then the principal will not be liable to the agent on the contract with third parties. The principal will also not be liable if the agent enters into what is called a negotiable instrument. Under the Uniform Commercial Code, which is called the UCC, a party cannot be liable on a negotiable instrument like a note if his name is not on the instrument or if the agent's signature does not indicate the agreement was made in a representative capacity. If I buy a piece of property on Disney's behalf and I don't disclose that I'm acting as an agent for Disney and I sign a note and mortgage to buy that property and Disney decides that they're not going to reimburse me, I have no recourse against Disney because I am the only one on the note and I did not sign as an agent on behalf of Disney. I put my name on the note and I can't look to Disney because the UCC prohibits it. There's also an issue with third parties entering into a contract with the agent that requires the agent's specific performance. The third party can reject the principal's performance of the contract in the agent's stead. For example, if someone were to hire a singer, then the principal could not come in and step into the agent's shoes to sing on the agent's behalf without the third party saying, "No, I only want the agent to sing. I don't want the principal to sing." If the principal or agent knows a third party would not enter into the contract if the third party knew the principal's identity, and the agent enters into the contract, the agent will be the only one liable if the third party rescinds the contract. If the principal is undisclosed, a judgment in favor of a third party against an agent when the third party comes to know the identity of the principal before judgment releases the principal. What this means is that if the third party sues an agent for breach and during the course of discovery finds out that the principal is also a potential party from whom they can recover, and they elect not to bring the principal in as a party to sue, then the principal is released. They had their chance and they didn't take it. So then the principal has no further liability to the third party. If there is a judgment against a previously undisclosed principal, that frees the agent from liability. What about liability for unauthorized acts? That's where it gets hairy. If the agent has no actual or apparent authority to act on behalf of the principal, but the agent nonetheless enters into a contract with a third party, the principal, regardless of classification, whether they're disclosed, partially disclosed, or undisclosed, the principal is not bound by the contract unless the principal ratifies the contract after the fact. Normally, the agent will be liable to third parties if he enters into a contract without authority. If the agent makes knowing misrepresentations to third parties about his authority, the agent can also be liable in tort to the third party. They can fraudulently induce the third party to enter into the contract by making false misrepresentations. We talked about that intentional tort in Chapter 7. Agents who exceed their authority for a disclosed or partially disclosed principal are liable for breach of the implied warranty of authority, but not for breach of contract because they're not parties to the contract. Remember, if the principal is disclosed or even partially disclosed, the only parties to the contract are the third party and the principal. The agent can breach the implied warranty either intentionally through a knowing misrepresentation, an intentional tort, or unintentionally, even through good faith mistake of the scope of his authority. He can be negligent in how he makes representations to third parties. In either case, the agent is liable for breach of implied warranty of authority if the third party acted on reliance of the agent's misrepresentation. If the third party knows or has reason to know the agent has no authority, the agent will be not liable to the third party. The third party can't enter into a contract when they know the agent has no authority to make it, take advantage of the situation, and then try to sue for breach. Now let's talk about tort liability of the agent and the principal. If an agent commits a tort against a third party, the agent is liable regardless of the classification of the principal or the liability of the principal. It is the agent who's going to be responsible for their own torts. The key is whether the agent's torts can be imputed to the principal such that the principal becomes liable in tort to a third party injured by the agent. Usually the principal is the deep pocket. And so a plaintiff looking to maximize their recovery may sue the agent, but may also want to sue the principal so they can reach in their pocket and thereby get a bigger reward. There are instances under the law where the principal can be liable for the torts of the agent. If the principal directs the agent to commit the tort, the principal is liable for the agent's actions. That's pretty self-explanatory. If you tell the agent to do it, then you're on the hook with the agent as well. If the principal, though not condoning the agent's acts, ratifies the agent's acts knowing that the agent acted improperly, then they're also on the hook equally with the agent for the tort. If the principal fails to provide proper instructions or guidance or equipment or tools to the agent such that the agent then commits a tort, then the principal can be liable for negligence as well. If the principal fails to use proper care in the hiring of an agent and does not do due diligence, then the principal can be liable for negligent hiring of the agent. When I became an adjunct, WSU did a background check on me, and I had to fill out a fairly lengthy application. WSU did their due diligence. Now let's talk about the plaintiff-friendly doctrine of respondeat superior. This is a legal doctrine that imputes liability for the torts committed by an agent to his principal via vicarious liability. This doctrine does also apply to the employer-employee relationship. In other words, tortious acts by the employee can be imputed to the employer so that a plaintiff can sue the employee and the employer for tort liability. Remember, corporations can only act through their officers or employees. Now, the principal or employer is vicariously liable, even without fault, because they negligently hired the agent or employee. The act of the officer or employee is the act of the corporation under the law. There's actually a pattern jury instruction in Kansas and most states on this topic, and jurors are told that if an employee commits a tort in general, the corporation is also liable. The principal is liable because courts believe that the agent is advancing the business's goals. So if they commit torts, the principal should be responsible for the bad acts just as they benefit from the good acts. However, there are limits to this doctrine. The agent or employee must be acting within the scope of her agency or employment. This is very important. Must be acting within the scope of his agency or employment. There can be no frolics, major side trips, or detours. The classic example is the truck driver. Suppose a business has a truck driver on their payroll and he is supposed to deliver a package to a client. He takes a little side trip to get a cup of coffee and on the way there hits a car and causes an accident and injuries. Can the person in the other car sue both the truck driver and his employer for the tort liabilities from that accident? The answer will much depend on whether or not the frolic was considered major or not. Taking a small detour to get a cup of coffee probably does not relieve an employer from liability. But if the employer takes a joyride to another state and causes an accident, that's clearly outside the scope of their employment, and so then the principal would not be liable. The rules are different if the employee is not an employee but is rather an independent contractor. So let's talk about principal liability for the acts of an independent contractor. Remember, an independent contractor is not an employee. The company does not control the details of the independent contractor's work performance. Therefore, the doctrine of respondeat superior does not apply to create liability for the employer because they don't control the independent contractor. However, if the employer hires an independent contractor to conduct inherently dangerous activities, the employer will still be liable in tort under strict liability concepts. For example, hiring a blasting company to bring down a building. If the blasting company commits a tort during the course of bringing down, say, that old motel we talked about, not only will they be liable, but the person who hired them to take the old motel down will also be liable. In addition, if the employer directs the independent contractor to commit the tort, the principal will be liable. That's kind of self-evident. We're now to the last topic in Chapter 20 that we're going to cover, termination of the agency relationship. An agency relationship can end either by operation of the parties or by operation of law. If the parties terminate the agency, there are a variety of ways to terminate the relationship. Here are the major ones: lapse of time, fulfillment of the purpose, occurrence of a specific event, mutual agreement by the parties, revocation of authority by the principal, or renunciation of authority by the agent. These are all well described in your book, so I'm not going to give you an example of each, but for testing purposes, I would know all of these on this slide. An agency authority can also end by operation of law. It can be terminated by the death of one of the parties, by insanity of either party, if either party files for bankruptcy, There can be a substantial change in circumstances such that the agency is no longer necessary. There can be a change in the law that makes the agency illegal. That could be impossibility. In other words, it would be impossible to sell this piece of property because we have found out that it is so substantially environmentally contaminated. There can also be terminated by disloyalty of the agent or war. Those are the major legal bases on which an agency relationship can be terminated. We have reached the end of Chapter 20.